An overview of private international law. Private international law, often referred to as conflict of laws, is the body of principles, rules, and at times, policies that indicate how a foreign element in a legal problem or dispute should be dealt with. Unlike public international law, which primarily governs the mutual relations between states and international organizations, private international law addresses ties between private entities, such as individuals or corporations, when those relationships involve cross-border elements. Historically and conceptually, private international law is considered a part of the domestic law of each country. The necessity of private international law is defined by the existence of a foreign element in a private law relationship or civil proceeding. This element may arise when the subject of the legal relationship is domiciled abroad, a significant legal fact occurred outside the jurisdiction, or the object of the relationship is located in another state. The globalizing world, characterized by expanding trade and increasing movement of people across borders, leads to an exponential increase in situations requiring private international law rules to provide certainty and predictability. The central tasks of private international law focus on resolving three main issues in a cross-border dispute: jurisdiction, determining which court of which state has the power, forum, to hear and determine the case; choice of law, answering which substantive law, of which state, is applicable to the legal relationship; lex causa, recognition and enforcement, determining whether a judgment or arbitral award from one state will be respected and enforced in another state. This system serves multiple objectives. One key traditional objective is the international ordering of state power, aiming to allocate regulatory authority between coexisting sovereign states and their legal orders. Another perspective views private international law as concerned with the national recognition of private rights, stemming from the exclusive territorial sovereignty of states, implying that rights vested in one territory should be recognized elsewhere. Ultimately, private international law aims to provide legal certainty, predictability, and to facilitate cross-border economic activity and personal relationships while respecting the legal diversity of private law. Private international law rules are drawn from various authoritative sources. Although traditionally national law, the increasing internationalization of commerce and personal life means that private international law norms often originate in international treaties. The theoretical underpinnings of private international law have varied dramatically. Early approaches emphasized rigid territorialism. The territorial theory, developed by jurists like Huber, Dicey, and Beale, stipulated that the laws of a state have absolute force only within its territorial limits. Consequently, courts do not apply foreign law directly, but rather enforce rights acquired under foreign laws. In the United States, this formalistic approach faced a revolution led by American legal realists in the mid-20th century. Scholars like David F. Cavers and Brainerd Curry rejected the fiction of vested rights, arguing that judges inherently make policy decisions when applying conflict rules. This shift gave rise to interest analysis, which sought to openly analyze the competing policy interests of states involved in a dispute. In contrast, the EU private international law revolution transformed its system not primarily through internal theoretical debate, but through external economic pressures, reconceiving private international law rules as serving a systemic public ordering function focused on the efficient functioning of the internal market. The EU rules are often more rigid than modern US approaches, aiming for certainty and predictability, and resurrecting the objective of minimizing concurrent proceedings and ensuring decisional consistency across member states. The increasing interconnectedness of the world has amplified the challenges faced by private international law. In the commercial sphere, private international law must facilitate productive transnational economic activity, reduce transaction costs, and uphold party autonomy, as evident in efforts like the Hague Principles on Choice of Law in international commercial contracts. In the realm of international mobility, Private international law interacts critically with migration and refugee law. For migrants and refugees, the recognition of personal status acquired abroad is often crucial for issues like family reunification. Article 12 of the 1951 Geneva Refugee Convention, for example, provides a specific private international law rule stating that a refugee's personal status is governed by the law of their domicile or residence, rather than their nationality, demonstrating how private international law provides a specialized framework for protecting individuals in vulnerable, cross-border situations.